Hello, I'm Bill Peterson, Minnesota probate attorney. Sometimes the procedures of probate seem to move slowly. This can make it easy to forget that there are timelines in the probate process. If you miss these, you may lose what rights you have in probate. Under Minnesota law, a statute of limitations is the legal deadline in which court action needs to be taken in order to assert the legal rights of a person. The laws affecting estates of deceased persons and their families have a large number of time deadlines that must be followed. You must use the proper procedure within those times, or you can lose your rights. The first deadline is that the probate must begin within 3 years of the death of the family member. It is possible to start legal proceedings to get distributions of the assets after those 3 years, but the processes are more complicated. As you might expect, when things get more complex, they also become more expensive. When one of the heirs files with the probate court asking to be appointed as executor or personal representative, a written notice is sent to the other heirs. The people who receive that notice then have 30 days in which they can file an objection to the person being named as personal representative. It is possible to later ask the court to remove that person as personal representative, but getting that done afterward is more difficult. If you are the spouse of the deceased person and you do not like the provisions of the will, you must file your objection within 9 months of the death or within 6 months of the filing of the probate. If the deceased loved one has a claim or potential lawsuit against someone else, the time for a personal representative on behalf of the decedent to take action may be running out. There are provisions of the law to suspend the running of certain statutes of limitations. However, it's always better to be safe with timely action. Once the probate process has begun, the executor or personal representative has 6 months in which to prepare and provide an inventory, which is a list of all of the assets of the estate, to the heirs and creditors. When the personal representative asks the court to approve the estate accounting or distribution of inheritances, any beneficiary who does not agree has a limited period of time in which to file an objection. Objections commonly include disagreements with how the estate is being managed, how much is to be paid to beneficiaries, or relating to the expenses of the estate. If you have a debt owed to you by the decedent, you have 4 months in Minnesota after the probate proceeding is begun in which to file a claim. For example, if you have had an agreement with the deceased loved one to provide care for that person for a particular amount per month and you have not been paid, you need to file a claim. If you do not file a claim within the time allowed, you may lose your rights altogether. If the personal representative disputes your claim, he or she can disallow it by sending a written notice to the claimant within 2 months after receiving the claim. Then after that, the claimant has 2 months in which to file a challenge in court to the disallowance of his or her claim. The time limits that I discuss in this video have a number of exceptions and possible extensions to them. However, the safe thing, of course, is always to file within the time deadlines so you do not have to go to the court to ask for an exception or an extension. As you can see, the probate court has many time deadlines in which rights must be asserted or those rights can be lost. If you have possible rights as a beneficiary or as an heir or as a creditor to an estate, you should consult with a probate attorney to be sure your rights are protected. time may be running out before you know it. I'm Bill Peterson, Minnesota probate attorney. If you are dealing with the estate of a loved one, I can help. Call me toll-free at 1-888-910-5297 for a free, no-obligation consultation. Deadlines in probate are important. Don't wait and miss out on your rights to your inheritance.